what do I feel is problematic with SB 94 as its proposed legislation? I think it's a tremendous mistake. This is the first time that any legislature that I'm aware of would be regulating retainer fees that are obtained by attorneys. I think that the effect of this law, once it goes into effect, is going to be devastating on the individuals that really need the help that attorneys provide to them in being able to contact servicers and assist them in getting loss mitigation relief. Unfortunately, servicers are not going to be offering their services to borrowers without the assistance of a third party, such as in some instances there may be non-attorneys that have done so, that comply with state law and offer loan modification services in California, but primarily with attorneys who have the ability to stop a foreclosure sale, for example. They're not going to be able to do that if they are not going to be paid. If a client comes into an attorney's office and says, I have a sale date in 5 days or 20 days, I said, you've got to help me. And the attorney's going to say, well, I can't accept a fee from you in advance, and therefore I just can't take on your case. What will happen to all of these people? This is a real tremendous problem. I think that the bar is supporting this position. I understand they support SB 94, and I think that the reason they support it is because they're very concerned about the fact that there have been a number of large firms that have been what they consider problems, that there have been many complaints about these large firms. Some of them have been shut down already by the FTC, or they've been shut down by other entities, perhaps the district attorney, the attorney general. And I think that they're looking at the bulk of clients. Some of them have thousands of clients. What the bar is concerned about is the fact that they have a very limited client security fund. Once they take over a law practice, for example, they come in and shut down a law practice, they have to come in and reimburse all of these clients for the fees that they pay the attorney. And if they have thousands of borrowers, clients, who have paid thousands of dollars, many thousands of dollars for each modification service, that will bankrupt the client security fund. So I think that is the reason that the state bar has a strong position in favor of SB 94. But I think that overall it's misguided because it's going to prevent people from getting the help that they need.
My issue is with the effect of it, the effect that it has on attorneys, and the fact that the Bar Association that I believed would be supporting our industry has now switched teams and is supporting another industry. I think it's similar to other efforts to quelch the effectiveness of attorneys by not allowing them to be paid. It's a way of getting around a constitutional, perhaps, issue of everybody being entitled to representation if they can afford it, by saying, no, you can have representation, you just can't pay them. Unfortunately, attorneys eat, and attorneys have houses, attorneys have car notes, right? And so we have a need to make money in our profession as well. And with the way that the loan modification business is going, it's stretching out so long that you cannot maintain the work for no money. And then because we're not charging exorbitant fees that would make up for it, as in a contingency case, it's worth the risk because at the end, well, there's a nice fee sitting out there for you. But when you're talking about a few $1,000s and you got to wait 8 months and pay a staff for that time period, I think it's unfair, it's unreasonable. What's going to happen, you can have the perhaps unintended or intended consequences, which is that homeowners simply are not going to have representation. Because as I said, lawyers got to eat. We got to pay our bills. And we'll sympathize with you. We'll take on as many pro bono cases as we can, but by and large, homeowners are going to be the one that's going to miss out. And I'm going to go ahead and say this. I was watching a seminar by, I believe it was the deputy director of the state bar, and he was saying that he sees the issues, but his concern is the consumer. And I think that maybe he's not seeing this correctly because it's the consumer who's going to be negatively affected by the legislation, because attorneys, darling, we're going to go on and go into another area of law. We're going to keep moving on because we got to eat, right? So it's not going to affect us. It's going to affect the homeowners. It gives the impression that you can't trust lawyers. And this is supported by the bar. That offends me, and it distresses me. And if I were to talk about my biggest frustration, I think that would be it, the Bar Association's failure to support lawyers.
Banks are taking people's homes. If you want to pass a law to protect the public and to keep people in their homes, pass a law against the banks. Don't pass a law against the consumer protection attorneys that are trying to help. This is really the banking lobby. You look at the senator that introduced it, Senator Calderon. He's the head of the Banking and Finance Committee. This guy works for the banks. He's you know, the #1 recipient of funds from the banking lobby. So that's the major problem with SB 94.
The underlying proposal in SB 94 is fundamentally defective. The concept of protecting a consumer will be totally eroded by the elimination of representation by licensed attorneys. It's my opinion that that is exactly what will happen if attorneys are not permitted to collect upfront fees. The fee structure itself is very modest when compared to the amount of expertise, the relationships established with lenders, and the amount of effort that is required and put forth in any loan modification process. If a consumer were to engage a lawyer for any other project, the hourly rate structure would, in Orange County, commonly exceed over $300 per hour. The processes that have been established and put together through the vast and varied experiences with lenders, the streamlining allows clients to engage the services of a lawyer somewhere starting at around $1,500 per loan modification, in most cases not to exceed $3,000. Anything higher than that would be under exceptional situations, and this represents a tremendous value to the consumer. SB 94 would effectively eliminate the opportunity for that value.